B4BConnect.com is speaking with Tracy Leahy, an attorney with Clark Hill PLC in Detroit, about the Internet Privacy Protection Act and what this new law means for business in the state of Michigan. Ms. Leahy, can you talk a little bit about the law for people who may not be aware of it?
Sure. On December 28th of 2012, Governor Snyder signed into law the Internet Privacy Protection Act. And the act prohibits employers and schools from requiring employees, applicants, and students from divulging personal passwords and user IDs for internet accounts like Facebook. The law also prohibits employers and schools from retaliating against a student or employee. Retaliating would be being discharged or disciplined or failing to hire that applicant for refusing to provide that information. The law basically followed a widely publicized but relatively rare practice of a handful of employers who were requesting Facebook passwords from applicants and employees as a condition of employment or continued employment. Several states quickly enacted legislation prohibiting the practice, including Michigan, Illinois, California, and Maryland. It's expected that the number of states that will prohibit this practice is going to double within the year, and there's also federal legislation that has been proposed. In terms of the law, it's narrowly drafted in Michigan. Anything in the public domain is fair game. So if you have a Facebook account and your settings are not set to private, that information will be available to your employer or school. There are several exceptions, however, for employers to investigate social media use by employees in three situations. The first is where the employer pays for the device and provides it to the employee. The second is where the employer provides the internet account to the employee to be used for business purposes. And then the third would be where the employee improperly transfers any type of confidential, proprietary, or financial data of the employer. Then there's also fines associated with a violation of the law. So a person who violates the law can be guilty of a misdemeanor and assessed a fine of not more than $1,000 plus attorney fees and costs. In addition, a person who believes that a violation has occurred can file a lawsuit 60 days after tendering a demand for damages and setting forth what the alleged violation is.
I guess how can a job applicant actually prove the violation? Even after making a written demand, taking documentation of the incident, and even filing a lawsuit, if the request or demand was just completely verbal, wouldn't it be simple for the employer to just deny the charges?
An employer could deny the charges, but an employee would need to prove a violation of the law through their own testimony or through an affidavit. And it's recommended that an employee keep notes of conversations that they've had during an interview where that information may have been requested. For instance, keep notes of the date, the time, the name of the interviewer, the specific question that was asked, and any witnesses who may have been present to actually hear what was said. In addition, after litigation is filed, the applicant would then be entitled to discover the names of other applicants or employees who may have also been asked inappropriate information and therefore get corroborating testimony of the violation.
For violation of the law, is the misdemeanor fine assessed to the actual individual who requested the information or the company itself?
The law defines an employer to include a person who is engaged in a business, profession, or industry, and also includes an agent or representative of the employer. So under that definition, both the company and the individual who requests the information could be found to have violated the act.
What prevents a job applicant from demanding money from an employer, actually getting that money, and then filing a lawsuit anyways?
Well, the employer would probably take care of that. Before an employer is going to pay any damages under the act, they're generally going to get what's called a release. It's a written document that the employee would sign acknowledging the payment and agreeing that they will not file a lawsuit or otherwise seek damages for the same violation.
And looking at it from the perspective of a job seeker who may actually could be desperate for a job, wouldn't it just be easier for someone to give up the information and try to get hired, as opposed to making demands and filing a lawsuit and basically ensuring that they will not be hired?
That's an interesting question. I think that this was the purpose of the law, so applicants are not put in that situation where they actually have to decide, is the job more important than their privacy? But certainly if that does occur and a violation occurs, then the individual would need to make that decision as a matter of their own individual interests.
Are there any loopholes for employers to get around this law? I mean, for example, can they hire an employee and use some type of probation period to access information and then fire that employee?
There are no loopholes, but there are exceptions. As I mentioned, an employer can investigate social media use where the employee is using a device that the employer has paid for, or where the employer has provided an internet account for business purposes, or where the employee is not using the employer's confidential, proprietary, and financial information in the best interest of the employer.
And do you have any kind of guess of how lengthy the process would be for a job candidate to make a claim, progress through the entire legal process, and actually receive compensation for the employer's violation?
That's difficult to say. If the employer admits the violation then and pays the fine, obviously that would probably be a relatively short period of time. However, if litigation is necessary, litigation is unpredictable and can be lengthy, anywhere for a claim like this from 4 months to a year, or possibly longer.
Well, that concludes this B4BConnect.com interview. Ms. Leahy, thank you very much for your time.
Oh, thank you for having me.
For our viewers, be sure to visit B4BConnect.com to read Ms. Leahy's full article about the Internet Privacy Protection Act, as well as a wide array of other news and articles that are relevant to your business.